Hi, everyone. Thank you for joining us this afternoon. My name is Marisela Martin. I'm the Community Engagement Coordinator with the Dallas Volunteer Attorney Program, also known as DVAP. DVAP is a joint program of the Dallas Bar Association and Legal Aid of Northwest Texas, with the purpose of recruiting, training, and supporting pro bono attorneys to do civil legal assistance for residents of Dallas County. Today, we have Brittany Moore, who's a staff attorney at Legal Aid of Northwest Texas. Brittany received her Bachelor of Arts degree from Mid-America Nazarene University in Kansas, then went on to receive her Juris Doctorate from South Texas College of Law in Houston. Prior to joining LandWIT, she was an Equal Justice Works Fellow, sponsored by the Texas Access to Justice Foundation, hosted by Beacon Law. Today, she is the LSC Pro Bono Innovation Grant Attorney with Legal Aid of Northwest Texas, and her project proposes to recruit, train, and mentor pro bono attorneys to take ID restoration cases to meet the much needed need within our community. So without further ado, I'm going to pass it on to Brittany to present her presentation.
Hi, welcome everyone. I'm gonna go ahead and get this PowerPoint started. Thank you everyone for joining. There we go. So today I'm going to be talking about obstacles to obtaining or renewing a driver's license or ID. I say that because generally, obviously you get both from DPS, and generally speaking, if you would get arrested for a warrant resulting from your driver's license, then the same could happen if you go to get your ID. So we always try to make sure that everyone's licenses are cleared before they get an ID. And then also that's the more preferable form of identification for most everyone. Driver's license eligibility cases. So it's about more than 50% of the civil legal needs for the homeless. Because they lack personal identification, they move, they're transient. And so they're constantly losing those identification documents. And that's why this work is very important to that population specifically. It's such a very basic thing that a lot of our clients can't gain access to benefits, housing, and then employment even. Most every job, even if it doesn't, it's not a driving specific job like Uber or driving a truck, they're still going to want you to have a valid driver's license. And that speaks to, again, the reliability of the person that they're hiring. Can they get to and from work? So it's a big deal to try to get the clients that we serve and the communities that we help those valid licenses, so that way they can take one step forward in their lives in maintaining housing, benefits, and employment. So just generally speaking, I wanted to touch on how we prep these cases if you take a case from us. So we do a lot of the front end work. We determine their financial eligibility. For us, we only represent people who fall below 200% of the federal poverty guidelines. We have them fill out a questionnaire for us, so that way we can check their licenses to see what holds, tickets, suspensions that they have. And then if we do find holds that we can help with or tickets that we can help with, then we do a retainer, we get it signed, we fill out financial affidavits that'll be submitted to the court with our motions. And then we do all that kind of on the front end before cases are assigned out to you all. In private practice, of course, that's something you wouldn't have to worry about. But here at Legal Aid, we are required to only represent people that fall kind of in that gap. So tickets, why we are able to help. So legal aid has not traditionally done this type of work. We've always helped with occupational licenses, but not necessarily fines and fees. But we discovered over time that this was a huge gap and a huge need, especially for Texans. People, so many people, everyone knows a cousin, brother, sister, a friend, someone from college that like has just been driving around without a valid license. And it's so common because in so many situations, especially for our clients, they just don't have the ability to pay, right? They ran the stop sign, got the $300 ticket. And for our clients, that $300 ticket is the choice between paying their electric bill, paying their portion of rent after the housing voucher, buying groceries for their kids or clothes for their kids, or paying this ticket. We know the decision they're going to make. It's not going to be paying the ticket. And that's why it becomes this like never ending cycle, because then a couple years later, they get pulled over again and get another two more tickets. All of those tickets then become warrants. And so they double in price, if not more. And then before you know it, they owe thousands of dollars in fines and fees that they are never going to be able to pay. And so that's where we realized at Legal Aid that we should help and we can help. I know in private practice, the object is to try to get dismissals. With legal aid, though, our client's biggest problem is their inability to pay. And so when we are going to the judge, we're saying, hey, if you can dismiss it, yeah, let's do that. But on the other hand, our clients still can't pay these fines and fees. So help us come up with a disposition that they can actually reach, that they can actually obtain a valid driver's license. And so for us, that's either a waiver or community service. And that's typically how we represent our clients. And then the Texas Criminal Code, Article 45, is where that legal grounds is described for why we're able to make those requests in the court. So where to begin when someone comes in and has driver's license issues? We will start with running 2 searches. They are both public, free searches. Anyone has access to it. Our clients, you, me, everyone. The first is the failure to appear DPS search. The link is here. And then the second is the driver's license eligibility search. So the first search, the failure to appear search, is what's called the Omni-based system. Kind of disclaimer though, so this system will list any outstanding tickets and warrants that are reported to DPS. However, I always ask my clients, are there any other citations out there that you know you have? Because everything will not be reflected on that Omni-based system. Almost 40% of the courts, if not a little bit more, do not report to this system, but that doesn't mean DPS doesn't know about them, right? Like if there's a warrant, they're still not going to let them renew their licenses. So one very common court in Texas, Arlington, right? I get a lot of clients who have tickets in Arlington, but Arlington does not report to the Omni-based system. So I always have to ask clients, do you have any other tickets besides the ones listed here? So that way we can add it to our representation, because if I'm helping you get your license, I want to help you totally clear it so you can actually go get it and not show up and they say, oh, you still have these tickets outstanding or these warrants outstanding. So that's my disclaimer. When you do run this report, make sure you still ask the client or potential client if they have any other citations that they know of, so you can add that to your representation. Again, this is something that we do before you take a case from us anyway, so you won't have to worry about that part. But in your own practice, that is definitely something you want to check with and talk about your clients, with your clients. Okay, so different options for how a client can dispose of tickets. Payment plan, that's pretty common. A driver safety course or deferred adjudication. And then there's time served request. The law has changed. It used to be $100 a day meaning 8 hours. But now it is minimum 150, but really there's a new statute that allows you to push for 200 a day for credit for time served. Another thing to note about time served is a lot of people don't realize, but it doesn't have to be that they serve time specifically for that ticket, right? The code that speaks to getting time served speaks to any time. So let's say you had a client who served time for an assault. right? And it was after the date they received the ticket. That's the only kind of parameters, is the jurisdiction and the date. So as long as it was after the ticket and it was in the jurisdiction of that court, they can actually use that time for that ticket to get time served. That may not have made sense. So let me give you an example. So if a client has served time at Lew Sterrett, Dallas County Jail, a year, and they got a ticket in 2016, they served the time in 2017, and they have Dallas County tickets, right? Dallas County Jail is the same jurisdiction as Dallas County courts. And then the date of the time was 2017, which was after the ticket was received in 2016. That time absolutely can be used to get time served for those tickets in Dallas County. And I think I have another slide that describes that again, if that wasn't clear. But that being said, I know a lot of attorneys think that it has to be that they were jailed for that specific offense, and that is not the case. You can apply anytime. State jail time is good time because it's long. And so they could owe thousands of dollars to a court. And if they've served state jail time, that is going to be a lot of good credit that they can use for their tickets. Anything like that. So just wanted to make that note. Community service is also a very popular thing that judges will grant. If they don't grant dismissal, waiver, or time served, they'll give them community service. The rate of community service is at $12.50 an hour, meaning if they owe $300 in fines and fees, divide that by $12.50, and that's how many hours they should get. And it should not be more than that. I say that because absolutely, if a judge wants to give less than that, they can. They absolutely have the power to. And actually, I would push for you to request that, right? Because with a client who owes $300, not a big deal. That's probably 20 some odd hours. But I have a lot of clients who may owe thousands of dollars to one particular court, $3,000. That is a lot of community service hours. And we want to make sure it's realistic. We want to make sure it's something our clients can actually complete to take care of these tickets. And so if I can ask a judge, hey judge, I know that the scale puts us at 89 hours, but can we maybe reduce some of that, reduce some of the fines, and then calculate the hours so that way we can get a more doable and obtainable amount of community service hours, especially if my client has a full-time job, is the breadwinner for their household. We definitely want to try to get them a reduction in the hours and even more time, right? Because there is a specific standard of time as well that is allotted for people to complete these hours. But we want to push for more time, especially if we know our client is someone who does work probably a minimum wage job, but they work nevertheless, and they need to keep that job and do the community service. So we want to be very realistic when we're making these requests. Excuse me. And then waiver of fines and fees. Of course, that's what we prefer. And then if the client is disabled, they will grant it. They'll just waive the fines and fees, often with a conviction and I warn my clients that we may have to plead no contest to get that waiver. But again, for my clients, the dismissal is great, but is not the goal. Their problem is that conviction or no conviction, this ticket is going to sit on their record forever and they're never going to be able to pay it. So if we can get a waiver, then great, that's even better. And if they get points that result in a suspension, we'll just get them an occupational for that duration. And we'll talk about what an occupational license is in a few slides. But yeah, so we can absolutely get waivers, especially if someone has a disability. So if you come across a disabled client, we ask them to give us proof of that by a doctor's note, or even just a statement from Social Security that says you receive disability benefits. And that is because the threshold to get Social Security benefits is so high that if somebody's getting it, yeah, they're definitely disabled. And so just the printout of that awards letter is enough proof for a court to grant that waiver for someone. So we have a set of pleadings already ready that we give to our volunteer attorneys, a template that you can use and draft and file in these courts for our clients. It includes all of these arguments, and you can just delete and edit, add the cause numbers, and that's it. Like I said, we do a lot of prepping before we give you these cases. And so we tried to set it up to make it as straightforward and simple as possible. And in fact, I already know whether the client you were assigned has a disability or not, or potentially can get time served or not. Another thing to note about time served is if I do have a client who asks us for that or tells us they've served time, you will need proof of that as well. So I let my clients know that they need to go and get that proof from the jail that they served their time, so that we can add that to the motion, just like we would their proof of disability. To get the waiver, we want to make sure we include that in our motion, so that way the judge will grant it. And I saw a question in the chat, and I will get to that at the end of the PowerPoint. FTA, so I was talking about the two searches that we use to find the holds and suspensions and tickets on someone's license. This is that Omni-based system at the failure to appear website at DPS that I was referring to. So here is an example to the right of what that search looks like. It'll show right there the name of the court, the address, all of their contact information will be there, their cause numbers will be there, the date of the offenses. Again, that matters to us for two reasons. One, if the client is requesting time served, but also two, because if it is more than 10 years, there's a good chance the prosecutor will probably just dismiss it anyways, especially if there's no plea entered on those cases yet. So those dates are something you want to note. And then the total fine amounts that they owe. As you can see, this particular client owes $5,000 to just one court, and that is not uncommon with our clients. Like I said, it just becomes like this this ball that just keeps rolling for them. It starts off with one ticket, and then over the years, it just increases and increases and increases. And by the next thing you know, they owe like $12,000 in fines and fees to all these different courts, and they're never going to be able to take care of them. And so that's where we step in. That's where we need advocacy, when we need to help them so that way they can get back to getting something so basic that is a driver's license. All you need for this search is just their driver's license number and date of birth. Again, the link was in the previous slides, and it is free. No one has to pay for it. You just need that information, and then you're good to go. This next search is the second link that I was referring to, the driver's license eligibility page. This page is from DPS. This will tell you whether or not their license is eligible and why or why not. So this is where you'll find those other suspensions, those things that prevent people's license from being renewed for reasons other than tickets, right? And so this is that website. Another thing to note about this website is if you come across an applicant or client that has had both a Texas ID and a Texas driver's license, you want to make sure to complete this search under both numbers. This search requires their driver's license number, last four of their social, and date of birth. But again, if you know they also have an ID, I would run the search again with their ID number as well and compare the two, because it is not crazy and would not be unusual to see that they turn up different results. Over the years, obviously people have had both, which is also the reason why DPS is asking people to surrender one if you're getting the other. Is because they're trying to consolidate all these records that they have. So it is possible that there may be a suspension on their ID that you did not see come up on their license search. So if you know of a client or applicant that has had both, make sure you run this search under both numbers. They've actually done a better job, I've noticed, where it seems like they've been matching here recently. But again, you want to make sure of that by just double checking and running that search really quickly. So you can see here in the right, it says in bold whether or not their license is eligible or not eligible. And then if you scroll down on that same site, once you pull it up, you'll see why. So here on the right side is this example of a couple suspensions that a client had. These in particular are SR suspension and liability judgment. So that basically means that this client got into an accident with no insurance. And the insurance company probably covered the other driver's damages and then sued this person for that amount, got a default judgment, and they sent that judgment to DPS, and DPS sent this suspension to that person. This is a very common hold. And then you can see over here where it says compliance instructions, it will have a list of options and ways that a client can dispose of that suspension. And that's not just for accident suspension. Any suspension that a client has on their license, DPS does this kind of chart right here to the right that will actually show steps for how they can relieve themselves of that suspension and drive legally. And then finally, if you scroll a little bit further down past the suspensions, if they have any, the last thing you'll see is this first thing up top that talks about the omni-based system. That's that search we just talked about previously. If you didn't run that search, this page will tell you you need to run it again because that is another reason why they will not be able to obtain a valid driver's license from us being DPS, is because of these tickets in the omni-based system. And so that will also be noted here in this search as well. And then here you can see at the very bottom, there are these things called reinstatement fees. So these reinstatement fees are not surcharges. One thing that clients get really confused about is surcharges versus reinstatement fees. Surcharges are gone. They were repealed back in 2019. So nobody owes those anymore. That program was horrible. I'm so glad it's gone. Good riddance. But the thing that does still exist is this reinstatement fee, which is not as crazy as a surcharge program. It basically is a fee that DPS charges for each suspension that a client or applicant might get. There are 4 different categories of suspensions. They will only get charged that fee one time for each category, even if they have multiple suspensions under each category. So that's something to note. It's just a one-time fee. It goes straight to DPS. There's no court involvement. It's not a warrant. They're not going to get arrested for it. It's just DPS will not give you anything until you pay that fee. And that's really the only consequence of it, but it's not like something that they can get arrested for. It's like an administrative fee that they have to pay DPS for getting those suspensions. And now to discuss the different types of suspensions and enforcement actions that DPS enacts on drivers in Texas. So the 4 categories that I was just talking about are ALR suspensions, department suspensions, mandatory suspensions, and SR suspensions. We can circulate this PowerPoint. Some of them are pretty wordy, and it's really just because if you want to refer to it in more detail later, you have the ability to go back. You will have the ability to go back and read these slides if you'd like. But I put them in there just for your information and to have it, but I will kind of breeze over some of this. So here is a general list of some of the mandatory suspensions. Mandatory meaning there is no way to relieve themselves of this suspension, but it will only be for a certain period of time, right? So it'll only be 90 days, or it'll be a 1-year suspension or a 2-year suspension. But after those 2 years, it will fall off and it will go away. During those 2 years, however, in most cases, in mandatory suspensions, a person can get an occupational license and therefore still drive legally on the road until the suspension falls off. So there are other options to be on the road until they can have a regular valid license if someone has this mandatory suspension. Some of these probably more common ones are the DWIs, people who get drug offense convictions or felonies, they'll get these mandatory suspensions. Driving while license invalid, that's another common one where DPS will assess these suspensions. The other category that we just talked about were administrative suspensions and revocations. These vary in end time. It could be a fixed amount of years, or it could be forever until you fix this thing that we tell you to fix. And we, again, being DPS. So again, some of the more common ones are driving while license suspended, medical hold, being incompetent to drive, So you get pulled over because a cop noticed that you were swerving a little bit, but it wasn't necessarily because of drugs or alcohol. It was because you couldn't see, or you ran a red light because you're colorblind, that kind of thing. Those would be the different types of administrative suspensions and revocations that can happen. Um, there's normally a hearing, well, always is a hearing before these suspensions are actually enforced. It is not very often that our clients get these hearing notices in time to attend the hearing. And that's really just because DPS sends it to the last address that they have on record, right? So I don't know about you, but I know for me, while I was in college in Kansas, my address on my license was my grandma's house in Irving, Texas. And so if they had sent me a hearing notice, I would not have seen it either. And that's often the case with my clients, especially my homeless clients, because they're using kind of a family member's permanent address, but they're transient and they're on the streets, and they very rarely check their mail at that permanent address. So it's not often that I get clients who are able to attend this hearing. But if you do, these hearings can be very productive. Judges, more often than not, are very understanding and will give clients more time to fix these issues before enforcing the suspensions. They will even give them, plenty of opportunities to explain themselves, or, tell them why this happened and what they're going to do to fix it. And so if someone can make these hearings, they can be very beneficial to preventing a suspension from being enforced on their license. Court-ordered suspensions, revocations, and cancellations. So these would be the results of a court order. Again, DWI or DUIs is a common one. Delinquent child support is also a big one. And unfortunately, one that is almost nearly impossible to overcome. If someone does owe arrearages and those arrearages are enforced and then a suspension is placed on their license, one of the only ways to really get rid of that is paying off the money they owe, which, if any of you have ever seen people's totals and arrearages, it's often a lot of money. I have found that you can negotiate with the Attorney General's office with something like that, especially if it's been a significant amount of time or the child is over 18. They let you start a payment plan, and then will oftentimes agree to release that hold as long as the applicant or client starts that payment plan. So there are ways to get around it. It can be a little bit tedious, but would be worth it in the end, because like I said, these child support holds, they're fairly common and they won't go away until something is done about it. And so they'll just be driving around without a valid license until that's true. Failure to renew as a sex offender, that's another one that I see a decent amount of times. And it's just because someone moved to Texas and just didn't re-register, or someone failed to register after a year. A lot of my clients don't realize they have to continuously register with DPS every year and keep that information current. There's no avoiding it. Or they think that, oh, I registered with the court. No, you still have to register with DPS. It's a separate thing. Yes, they might be aware of it, which is why you have the suspension. But until you actually go there in person and give them your identification and address, they will put a hold on your license. Denial and issuance of renewal of driver's license. So that's pretty self-explanatory. It's when you go to DPS and they say, nope, you can't have your license. And then there's probably a reason why attached to it. And here are some of the reasons that they may get denials: furnishing alcohol to a minor, physical or mental incapacity. I think I briefly touched on that in the earlier slide, where if someone has these medical holds, they can relieve themselves of that hold if that medical condition has been remedied or treated in a way that would make them safe drivers. But it requires submitting that proof to DPS, which is a little bit of a process, but is definitely possible. And DPS actually does have a step-by-step online for how people can relieve themselves of these medical holds, especially if they have addressed that condition where DPS thought they may have been unsafe drivers. Occupational license. So as I mentioned earlier, there are certain suspensions and revocations that really you can't do anything about. And so the only option would be for the person to get on the road by way of an occupational license. So this is a restricted driver's license, meaning that they're either going to have to keep a log of where they go, where they drive, and when, or they will have fixed periods of time to drive. So they work at 8 a.m. so they can drive from 5 a.m. to 9 a.m. in the morning, and then they get off at 5. They can drive again from 3 p.m. to 7 p.m. at night. So things like that is why it's restricted. It's restricted by time and location, even county, right? When you fill out one of these petitions, you actually have to include the counties that this person will be driving in and around. Here's the code about occupational licenses. Another thing to note is that they cannot have a CDL and have an ODL. So I'll have clients who will request an occupational license and they're like, yeah, because I'm a truck driver and I gotta renew my CDL too. And I'm like, you still can't do that. Yes, this occupational will get you on the road as a regular driver, but it will not make your CDL eligible for you to drive that truck. That CDL will still be revoked and suspended. So that's another thing to note if you come across clients who ask about that. Proving essential need and interlock requirements. So there are two types of occupational licenses. One is essential need and the other is interlock. Essential need is the most common and they're straightforward, pretty simple. Most judges won't even require a hearing if you file the paperwork in support of properly. The support for an essential need is exactly that. Just prove up that need. So if they have a job, it's pretty simple. You just have to get a letter from their job showing that they actually work. And where they work. If it's a single mother with kids, she has to transport them to and from school, doctor's appointments, get groceries. All you need, I submit a food stamp letter that lists out her and her children that are getting benefits. Those are different ways that you can prove up an essential need. People who care for elderly parents, we've gotten occupationals for that. Any sort of essential need you can make an argument for to get an occupational license for someone who has a suspension and needs one. The other type is an interlock occupational. So these are a little different because it means that the suspension the person has, the client has, is a result of a DWI. A couple things to note about these is these are a little bit more involved. You will likely have to go to a hearing, and that hearing will be in the same court, in the district court for which that person got that suspension. So they had a DWI case in whatever district court. That same court is where you will have to be requesting this occupational license. You have to go back and ask that judge that took them off the road if they can get back on the road. That being said, if your client has had 3 or more DWIs on their record, it is not likely that you will get this occupational granted. And you have to kind of imagine it from the judge's perspective, right? Like, you do this over and over again. I don't trust you on the road. I'm not going to put you on the road for you to potentially kill someone. And so you kind of have to picture it that way when someone does come and ask for an interlock ODL. And because at the end of the day, especially for my clients, I don't want them to have to waste the money and time on all of the requirements that is an interlock hold, which is the breathalyzers, the SR22, and all the other probation fees they already have to pay for their criminal case. All those things are very expensive. And for my clients, they don't have that money to begin with. And I would hate to send them down a road that I know will not be successful. But if they have 2 or less, absolutely, you can. I would go ahead and petition for it and see what happens. I always talk to their probation officers to kind of see the likelihood and their gauge their support of this interlock ODL, because if the if the probation officer is on board in that court and says, yeah, I actually sent them to legal aid to go get this occupational because they've done so well, they're ready for a job, they're always clean, they always show up for their check-ins, then I know the judge is going to grant it, or is very likely to grant it. And then I also know that the DA won't oppose it, which is another big thing. These interlock, they are adversarial. So the DA can oppose it if they choose. But if you have the support of the probation officer, they probably won't. And I've never had one that did, where I had the probation officer support for that person getting that occupational. SR22 insurance. So as I mentioned, to have an occupational license, you are required to maintain SR22 insurance for the duration of that license. SR22 insurance is basically just liability insurance, but it's a special type specifically made for people who keep driving but aren't supposed to. And that's what it is. So I have clients all the time. They're like, I can't get insurance because I don't have a license and I don't have a car. I was like, yes, you can. It's called SR22 insurance. It's specifically made for you because you still keep driving and you still keep getting tickets, and DPS knows it. And that's why they're requiring you to get this SR22 insurance. I tell my clients, shop around. They vary in price. Some cost more than regular insurance, some cost less. So I always advise my clients to just get a few quotes before they land on one, because they might be able to find one that's more affordable for them or their family members who are probably helping them pay for it. After you get an occupational license. So this is kind of important because I even get this from attorneys as well as clients. Once they get the order signed and granted from a judge, they're like, yay, I got my occupational. No, not yet. You still have to send that order with $10 and or reinstatement fees if the client still owes them those reinstatement fees that I discussed in previous slides. All that needs to be sent to DPS within 45 days. That order, yes, is valid the moment the judge signs it. That client can get in a car and drive with that order in their car when they leave the courthouse. However, after 45 days, it becomes invalid. What they can use is the card from DPS. So if that paperwork and that money is not sent to DPS within a reasonable amount of time for them to get that back within 45 days, then they're back to square one. All that work was for nothing. So those orders and that $10 needs to be sent to DPS after the order is granted. So that way DPS can then mail back it's like an actual card that is their occupational license for them to use moving forward. Because like I said, that order will only be valid for 45 days. So here's an example of the templates that I send our volunteer attorneys to work on these cases. As you can see, the first page is a cover letter. It'll have the court information, the client's name, date of birth, license number, their outstanding causes in that court. And like I said, you can kind of delete and add the sections you need, whether if they're asking for time served, leave the time served section, or if they're not, take it out. Same thing with the waiver of fines and fees. That's typically in there for all our cases. Even if we are requesting time served or a waiver, we want to keep that indigency language in because that's the default. If you don't want to grant time served, that's okay. Our client's still indigent. And so we're still requesting an alternate disposition other than paying the fines and fees because they can't do that. And here's why. And so here's the motion on this next page to the right. It has all of the necessary codes for the judge to review if they need to, as to why they are able to grant this finding of indigency along with a waiver and or community service. The next few pages of that template. This is completed for you as well on the front end. Should you take one of our cases, I complete these with the clients. It's a financial affidavit that explains their financial situation to a judge, so that way a judge will find them indigent. So it lets the judge know whether or not they're homeless, whether or not they're employed full-time or part-time, their percentage, where they fall on the federal poverty guideline based on their income and household size, whether or not they receive unemployment, food stamps, any other public benefits, housing, whether they receive child support, all of that will be there in front of the judge to review, as well as their expenses. How much do they have to pay in rent, whether or not they're able to pay it? Because in a lot of my clients' cases, their rent is $700, but they have to get help to pay it, right? But that's still an expense that they have that shows the court they do have these expenses, which typically exceed their income. And so this is the reason that they can't pay these fines and fees. And we want to make that clear to the court. And that's what this document does. And it also lists their dependents, their children, any other outstanding debt they might owe that they can't afford, repo debt, credit card debt. And then also number 8 is where I enter that line about the plea. I make sure clients know that if required, again, that's if required, for the finding of indigency, we will enter a plea of no contest on your behalf. And are you okay with that? And then we want to make sure the court knows that when we send in this affidavit. But I do let my clients know that we do have dismissal or deferral options that of course we would push for, but I always want to prepare them for that worst case scenario, which is the potential for us to have to enter that plea of no contest. Again, for our clients, it's great if we can get a dismissal or deferred, but at the end of the day, their biggest issue is that they can't pay for these fines and fees, which is why they've been sitting there for years and years and years. I mean, I've had 60-year-olds who got their license for the first time because of how many fines and fees that they owed. And so that's not an uncommon thing. And then the last page of that affidavit, it used to be a notarization. So that way the court knows that it's a sworn statement. But since we kind of transitioned to virtual due to COVID, we replaced that with a declaration, which still kind of has the same weight. Essentially, it provides that kind of prima facie evidence that this person is indigent and cannot pay. We also have our usual legal aid certificate that we include for most of our clients, just to add to that kind of, what the client statement said is true. And they also qualify for us in our services, being a legal aid. And then finally, a proposed order is the last page of that template. It gives the judges the options to dismiss, grant a waiver, grant community service, how many hours, and due by date, and then also to grant a deferral upon completion of community service. So that is another thing, and a piece of code that was added to legislation that will allow us to request that deferral option. Because a lot of times the courts will say, well, they can either do deferred and pay the deferred fine, or do the plea and enter community service. That is not true. You can push to get both. I would like to accept the prosecutor's offer for deferral, but instead of paying the deferral fee, I'd like to replace that with community service. So that's definitely something we want to request and start trying to get for our clients, because at the end of the day, it's not fair that if I could pay that $200, I can get my ticket dismissed. But if I can't, and I have to actually do more work that is community service, then I can't get it dismissed. It really doesn't make any sense, because it's actually, if my clients had the ability to just slide a card, of course they would do that, but they can't. They're going to go out into the community and serve the community and then come back and still have to face a conviction. That's kind of not fair, right? And then the code actually allows us to do that and request that. And so we definitely make those requests for judges, especially if we are required to do a hearing. Which is actually another thing. It is not very often that we have to go to hearings. Most of the time, because as you can see from this template, the judge has everything in front of him to make, or her to make their decision, right? They have the proof of their income and indigency. They have the plea if necessary. We give them the options to dismiss, waive, or grant community service or deferral in our proposed order. They have everything they need to just sign this order and mail it back to us. And so in most cases, we do not have to have a hearing for our clients. Occasionally, yes, there are a few courts who may want to see us or our clients in person. If that happens, we are able to get virtual hearings, telephonic hearings, and things like that. It is, especially for our volunteer attorneys, that is not an uncommon request. And, judges appreciate that, you guys are trying to help us work through this huge number of clients because of this huge need. And so that is always an option as well, should something like that occur. Community service. If a client is ordered to complete community service, one of the things to note is if your client tells you that they are in right now working to get their GED, or they're in a drug and alcohol rehabilitation program or a counseling program, things like that can actually count as community service. It needs to be discussed with the judge first, and he needs to approve it and say, yeah, that's fine. But you absolutely can ask them to count that as a person's community service hours. It's kind of that idea of if they're trying to better themselves and better their lives and actually use this license to get a better job, it kind of falls into that same premise, right? And so absolutely it can be counted as community service per the code. Issues with community service. Of course, I'll get this question. My client doesn't want to do community service. They said they would, and they didn't. That does happen. And so what I always tell volunteers is you do not have to be on the hook if you do not want to. Your job was to get them that disposition, and you did when you got them that order of community service. And so if a client doesn't complete it, we can withdraw. Personally, if a client comes back and is in communication with me and says, Brittany, I just need more time. Like my kid got COVID and we were out for 2 months, and that was the period of time I had to do my hours. I just need more time. Of course, I will send in a motion or just call the court, sometimes is all you have to do, and request an extension, and they'll give us a new due date. I'm absolutely okay with doing that for clients who are actively communicating with me, have a legitimate reason why they didn't complete their hours on time. Yes, I'd be more than happy to say that, what you just told me, to a judge to request more time for you, or even a reduction for you, or even a waiver again for you. But if someone just doesn't do it and doesn't care to do it, then yeah, absolutely. We can just close the case and withdraw to make sure you're not hounded forever and all time regarding this case. But that is not something I ever want volunteers to worry about when taking these cases. Again, the calculation is $12.50 an hour or $100 a day. And then what else? If client does a portion of the hours, yes, they can still use that to credit for credit in their tickets. So let's say they were ordered 60 hours, they did 30 and still have 30 remaining, and they just want to pay the remainder. Maybe it's tax season and they can pay the rest of that. Absolutely. They can turn in those hours. The court should apply that credit. It should reduce the fine that they owe by half, and then they can just pay the rest off if they'd like. So I always tell my client, if they want to do that, that's how they have to do it. They can't do it in reverse. You can't say, I want to pay and then do community service. No, you need to actually try to complete community service first, and then you can credit that. And then whatever's left, if you want to pay that, go ahead. And they sometimes get family members who will volunteer to help them pay. And so that does happen from time to time. Here's the relevant code if you ever want to refer to that for why we're able to get these finding of indigencies for clients so they don't have to pay, why it's just and fair. The different legislative changes that have led to this reform in representation, indigency representation for people with tickets or Class Cs. Again, if you're not familiar with that, Class Cs misdemeanors are tickets. So tickets fall into that category. Class C misdemeanors are also non-traffic cases. Our volunteers will never get non-traffic cases. That's something we deal with. But more often it's for our homeless clients. We want to make sure that we fight that kind of criminalization of homelessness. So loitering, ticket solicitation, things like that. Or not solicitation, I'm sorry, panhandling. All of those crimes of homelessness, especially with the homeless ban that's in Texas right now, where they can't camp in tent in different places. So we want to make sure that people aren't being punished for being homeless, but those are also Class C misdemeanors as well as tickets. And these, like I said, are the legislative changes and improvements that have given us the ability to make these arguments. Another big thing to note is, especially for youth offenders who get tickets, they have to be offered community service on a deferred model, especially if they are in foster care. I actually believe foster care now, thanks to 2021 reform, it has to be waived. So this is different parts of the code if you'd like to reference it. Oh, another thing to note, even if a person has already appeared on the ticket, pled on the ticket, or it's a KPS, they can always come back and still make an argument for indigency. So we get that sometimes from courts, and like, you can't do anything. They've already entered a plea. I know, but I can do something, says the code. And we still need another disposition because they still can't pay this, or maybe they previously entered a payment plan. We can still kind of try to make that request for the judges and try to get another disposition of community service or waiver, especially if circumstances have changed. Case outcomes. This is quick work because, like I said, we do a lot of the prep work on the cases. By the time you get it, you have the cause numbers, you have the court information, you have the client's information, and the template. And all you got to do is fill it in and file it, and then just follow up with the court until you get your disposition. And so very quick work, should not take ever for one case more than 4 hours total, and very big impact, right? As I mentioned at the beginning of this presentation, this very basic thing that is a license is access to so many different things, to jobs, to housing, to benefits like Social Security. I mean, and I don't know if there's anywhere you can go where someone doesn't say, show me your ID. And then, you know, that preferable ID obviously is going to be a license, because that's what guarantees, or not guarantees, but helps you with that ability to be employed. They can get licensed, they can get their kids to school. I had a client tell me that the school wouldn't let her pick up her daughter because she didn't have a valid license. That happened. And so there's so many things that not having a valid license could affect. I mean, I thought that was interesting, but I guess it makes sense. You know, they don't want kids getting into cars with, you know, someone driving illegally, I guess. But it was very strange. But that being said, this very small, easy thing, easy case can make a huge impact in our clients' lives. And it does. They show it. They are very appreciative of it. They are so grateful for the work that you guys do when you help us with these cases, that we do for them when we take these cases for them. They understand the difference that it makes for them. They can't even rent a car without a valid license. Here's another rundown. Like I said, you know, you do this 1 hour training, you get credit, you take a case. It's not going to take you 2 to 5 hours, maybe. It's maintained in our case management system. So you send us the updates, we keep it in our file. We'll check in with you every once in a while. We'll mentor you. The mentor for these cases specifically is me. You will have my phone number, email. We will never just kind of leave you hanging on a limb out there. Like, we'll make sure that you get through it, and we'll get through it together. And like I said, we are here for we offer these resources to everyone, our CLEs, our practice manuals. Like I said, you're going to get our templates, anything and everything that you might need to take these cases to the end for our clients, and provide a level of advocacy that you can be happy with, and that our clients will be happy with. And questions? Oh, that wasn't a question. Does anyone have any questions that they want to put in the chat? No, I don't see any. Here is my contact information if you need it.